Hey everyone, Harry here to talk about today's big arguments in the Supreme Court. Big argument, but almost 3 hours of it in the case involving immunity for former presidents. And I say that advisedly because that's what it was really sounding like. A majority of the court, the conservative majority of the court, was thinking about. In other words, not thinking only about Donald Trump. The progressive three, Sotomayor, Jackson, and Kagan, were in fact thinking, can't we just take care of Trump? Which is exactly what the special counsel wants. And I got to say, exactly what so much of the country wants. Both people who want to see, Trump have accountability, but, even more broadly, people who who think it's important that when voters go to the polls in November, they know if one of the candidates is a felon, and not just a felon, as Trump might be after the New York proceedings, but is guilty of an atrocious, maybe historic crime against democracy. The argument did not go well from that vantage point because there were all kinds of hypotheticals and questions and concerns and issues having to do with presidential immunity that in instances that just don't have anything to do with Trump. I remain of the view that the court is never going to give him immunity, a pass on everything, but it actually, on top of everything else, well, first to get to the immediate thing everyone was looking at, would this produce a remand that would require some exposition by the lower courts and therefore its immunity, another trip up and down, and therefore butting right up against the election? I think the answer is yeah, it will. And indeed, it looks like the opinion could be multiple opinions and could set down different standards and factors and stuff that would be not even a sort of simple remand, but a complicated one, maybe various opinions in the Court of Appeals. I mean, they were really making what could be a simple case, that is a case that just said immunity, are you kidding me, for Donald Trump, and made it instead immunity maybe for different presidents. One thing they really were wrestling with was the notion between official and unofficial acts, and then even more within that, the distinction between acts done by a president based on presidential type powers, but for a bad motive, like you appoint an ambassador, but for a bribe, or, to me, even the famous SEAL 6 hypothetical, you use military power, but to assassinate a rival, those I thought were in grave doubt after the opinion, because a number of the justices, they were shifting. It's clear that the three don't want to go that way. It's clear that four, probably, including Kavanaugh, have real problems with immunity, and the focus is on Barrett and Roberts, if there's to be any kind of hope or silver lining. But the problem was there's such shifting kinds of thoughts and concerns. So the one I was just getting at is the notion that it somehow would be improper for the courts under separation of powers principles to evaluate a president's motive in doing something. So as long as the difference between official and non-official would be as it was, say, in the Blassingame case that was specifically brought up by Gorsuch, is Trump acting as an office holder or a candidate for office? So in that way of looking at things, when he is, on the actual January 6th date, or the phony electors, that might seem non-official acts, but dealing with the DOJ and telling them to lie to Georgia and say, we think the election was flawed, they could say that's an official act if they're not thinking about motive. I think it's really kind of gross departure from normal criminal law, which has everything to do with the intent behind something and what exactly is wrong with the Supreme Court applying normal principles, or the courts as they do for every other citizen to the executive to figure out motive and intent, which, is the absolute critical factor in a crime. It doesn't appeal to my sense of how the criminal law works, but that was one possible distinction. Then there were more, even crazier. Gorsuch suggested that maybe you would require Congress to make a clear statement that they meant to include the president. Why would that be? Why wouldn't the assumption just be any criminal law applies to the president? But this is a sort of gimmick they've pulled before, kind of out of thin air, and say Congress has to be express about it. Kavanaugh, and with Alito's quick Me Too, suggested that the first charge in the indictment, 18 U.S. 371, fraud against the United States, was a little bit too vague, and in this context could be used by a meanie successor prosecutor to go after a former president. And recall, just last week, the court heard argument in a case involving charge 2 and 3 in this indictment, involving obstruction, a substantive count of obstruction and a conspiracy count. So you could see ways in which not only, I think it's quite likely that hope for a trial in 2024 is, by the boards, but you could see ways in which they could really just carve off counts and theories and, leave not much. Maybe just the January 6th conduct itself, or the collectors, but those under different statutes. In other words, by the end of the 3 hours, it seemed as if there was a real risk, not just of a remand, but of an actual holding, and a kind of a cryptic one at that would actually not totally get Trump off the hook, but make it a lot easier for him. For example, this official versus non-official act distinction, when it first came up, Trump was against it in the civil trial. But when asked about it today by Gorsuch, his attorney Sauer leapt at it. Sure, that sounds good, because that would he notices that in the criminal context that would make a lot go away. Anyway, I thought that it could be a very momentous and pernicious opinion to 3-syllable SAT words, but in the sense of A, keeping the trial from going forward, B, shaving maybe substantially the charges against Trump, or invalidating some of them, and C, taking a giant step toward the deeply anti-constitutional principle that, or away from the principle that we have a president, not a king. Get special rules of immunity in the criminal context that really seem out of keeping with the court's, jurisprudence to date, and just basic assumptions of what it means to have a president, not a king. All in all, the best thing one could say is things were a little bit murky. Maybe Barrett and Roberts possibly make common cause with the three progressives, and something that's kind of limited. But all in all, it seemed the worry about remand was definitely realized, and the worry that most people didn't expect to anywhere near this extent of an actual bad substantive opinion was very much on the horizon by the end of the 3-hour argument. I think a rough day for accountability, and a rough day for the Constitution, and another opinion from the Supreme Court that could really be hugely controversial and cut against the grain of important constitutional principles. So there you have it. Talk to you later.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.